in terms of lands and resources. Louise has made it her business to use the words and policies of the Canadian legal framework against the authors of these policies and to win legal battles that have stood for over 100 years. But before I was ever aware of the depth and breadth of Louise's contribution to the changes she has made to the legal landscape in Canada, before I was to embark on my own healing journey, and I first knew her as a mom with 2 young kids sitting around the kitchen table, sharing meals and laughter over the antics of our kids, and for enduring friendship of the heart and mind. I am ever grateful, and with its loving and it is with loving and open arms we welcome you back. Thank you, Louise, to the naval territory. Not as an afterthought, but as the first and foremost, I should have. Yes, thank you.
Well, I'd like to first just thanks Nima for allowing us to have this important conversation on the territory and how beautiful it is to have Elliot right here. I worked with his father for many, many years. Right, Elliot, and for the beautiful prayer that got us started in such a good way today, and for being invited to speak to you. This is my annual, it's become an annual pleasure. Laura invites me to speak to this class every year, and I look forward to it. I don't know, there's something about this place, it's coming home to the rainforest, to visit with Laura, to see you guys, all who's coming up. And it's just always, I wake up with a happy heart when I'm heading over in your direction. So I wanted to leave some time for us today to talk. So I'm going to give you, I'd like to overview some things with you, and then I'd like to have some time to hear from you. So I'm going to ask you to go back in your minds to a time when Indigenous peoples' territories were stewarded beautifully and successfully for generations upon generations under Indigenous law. And the explorers from the European continent with an entirely different worldview were setting sail over here. And the law which governed the Europeans coming over here was actually a law which was negotiated by some Indigenous people back east, the Royal Proclamation of 1763. When the British came over initially, they told the Indigenous people, their Iroquois and Algonquin allies against the French, that they would protect them against other Europeans who may not have their best interest in mind. But when the war between Britain and France was over, and the British did not remove themselves from the outposts where they had located themselves, there was actually, the result of that was that Chief Pontiac took up arms and was going to attack the British and drive them out. And the result of that was the George III proclaimed what was the Royal Proclamation, which said that Indigenous laws and legal orders and Indigenous people's rights to the land, that would be respected and continued to them, and that the Crown would embark upon a process of treaty making where by the incremental perfection of Crown sovereignty would be realized. So as treaties were concluded, the Crown's agreements with the Indigenous nations would form the basis of the foundation of this country, which would be then a country which would grow based on the rule of law. And so the Royal Proclamation, it might sound like an old word, but you know, it's been the most enduring law. It still finds expression in Section 25 of the Constitution in 1982. And recently courts have said that it is part of the constitutional framework. So this actually is the first piece of our Constitution, the Royal Proclamation, which required the Crown, it constrained the Crown, it put obligations on the Crown to recognize the pre-existing rights of Indigenous people to their laws and to their lands as legal rights. and then the incremental perfection of Crown title that way. And this relationship became embedded in the DNA Act. So under Section 9124, the federal government was duty-bound to safeguard the obligations of the Crown and got jurisdiction over Indians and lands reserved for Indians to protect the Indigenous people from the provincial government's conflict of interest, because the province got the lands, mines, minerals, and royalties under Section 109 subject to interests other than that of the province, which are the Indigenous interests in the land. So the constitutional framework is not all that bad. It actually envisions two legal orders, Indigenous and Crown governments, and agreements whereby these governments would live in a treaty or treaty federalism or in a relationship which sees two titles, two jurisdictions working together, one not overpowering the other. This all is good in practice, and good in policy, and good in theory, and good in constitutional principle. But actually, something else came over to North America besides the law, and it was a deeply held, misguided thought process. I'm going to call it a thought because it really is nothing but a thought, but it got embedded in the cultural imagination, and it was the thought that was carried over to North America by the settlers based on the superiority of races and this hierarchy of races, that there's somehow in the colonizing process, there are races like, for example, those that were dealing with industrial development and had developed compasses and the ships, and in fact the European cultures were at the very top of this scale of civilization, the thought went. And at the very bottom are hunter and gatherer societies who hadn't really began the ascent up to social Darwinism into this achievement of democracy and our great economy and Christianity. But the superior cultures would bring the promise of all of this development to the inferior Indigenous people, and that Indigenous people would eventually see the ways of their beings that were primitive, and they would move up the ascending ladder and become civilized like the Europeans. And this racist doctrine translated into legal positions. So what legal positions came out of that? One is the doctrine of discovery, which is by planting the flag, the Europeans somehow gained some supremacy or control or domination over the country, and so that's a superiority doctrine, and that was accompanied by the doctrine of terra nullius, which was to say that it's not that Indigenous people didn't live here, but because they were so low on the scale of civilization, they didn't really have concepts of land that were cognizable under the law. And so these two doctrines, the doctrine of discovery and the doctrine of terra nullius, were actually far more powerful than the constitutional law. These doctrines became embedded in the mindset of those that actually began control. And out of these doctrines, we had domination, dispossession, divide and conquer, delay. There was a whole subset of behavior that translated itself into legislation, into policy, into government negotiation mandates, into legislation, for example, under the Indian Act, where Indigenous laws, the very institution of Indigenous laws were outlawed, where the potlatch was outlawed, where Indigenous languages were repressed and suppressed, where residential schools were set up to accomplish the tasks that the dominant society felt was part of the evolutionary process of humanity. And this is the terrain that the legal cases that I've been working on were actually planted. So what I should just give you a bit of a moment where I just wanted to say to you guys, just follow your opportunities, because whatever life presents itself to you is the opportunity that allows you a choice of what it is you are really meant here to do. And I stumbled upon my work as a lawyer working with Indigenous people by one of those opportunities. I had actually quit the law firm that I was working at. I was taking a hike down the Grand Canyon, and it occurred to me that I didn't want to practice criminal and family law. I just didn't like the process of charging people when they were in a lot of pain, a lot of trouble. They didn't have money, and so they had to pay me to help get them out of it. And it just didn't fit quite right. So I arrived in Vancouver, and I didn't have a job. And then a mutual friend of ours, Lauren Me from Alert Bay, she and her friend had been beat up by police at the back, in a back alley, and she called me to bail her out. And I went to the court to do that. She had also called what became also a friend of mine, who was then a friend of hers, to bail her out too. And that was the late Art Pape. And Art knew that the Grand Chief George Manuel, who was across the street, he was going to meet him for lunch because he was looking for a lawyer to represent the Union of BC Indian Chiefs at the West Coast Oil Ports Inquiry. And I just met Art, and he invited me to come to lunch. I was just following a friend to lunch. And George wasn't the least bit interested in talking about anything because he had a speeding ticket. And he was worried about it because he was an organizer and he needed his car to do the work he did. I didn't know anything about Aboriginal and treaty rights, but I knew a lot about speeding tickets because the firm that I had just quit, one of their clients was a automobile association, and they gave free defenses to speeding tickets. As an Article student, I must have done about 50 of them. So I took a look at George's speeding ticket, and I said, I had no problem. So I took him across to Maine, and not only did I get his speeding ticket thrown out, but every speeding ticket in the province that looked like that, it got ditched too. And George just said, well, if you could do that for speeding tickets, what can you do for Aboriginal and treaty rights? And so he hired me to be the lawyer on the West Coast Oil Ports Inquiry for the Union of BC Indian Chiefs. And that became the beginning of a beautiful life that I just feel so privileged to have been able to live. You know, it's interesting, the West Coast Oil Ports Inquiry was, I guess it's now close to 40 years ago. And the threat was that tanker traffic carrying oil could spill and destroy the Indigenous people's fisheries. And the Indigenous people had organized to speak at the inquiry, and it was the first time there that I heard the land question. It was the late Godfrey Kelly from Haida Gwaii, and he was on a panel explaining why the tanker traffic was a threat to, an unacceptable threat to Indigenous cultures in BC. And you know, I hear that question still in my mind in a number of ways. He said, like, where's the government's bill of sale? And I thought, yeah. And then he said, how is it that the government got power? Where did the government get power to destroy our fish when the Haida have never concluded treaties? And you know, it was kind of a question waiting to find me because I had grown up Jewish. I am Jewish. I grew up as a post-Holocaust kid, and all my growing up life, I always wondered, how could Jewish people be sent to be murdered under cover of law? I just couldn't figure it out. This was the law of a democratic European society. It may be questionable how democratic the Third Reich actually became, but nevertheless, this is one of those so-called top-of-the-scale of civilization societies under this bizarre social Darwinism ladder of civilization that murdered 6 million people under cover of law. And so when I heard Godfrey Kelly say that, I go, yeah, if you could murder all those people under cover of law, bet you that they stole all this land under cover of law. And it was kind of the beginning of, you know, a question which would guide the rest of my legal life. And so I did have the honor and great privilege of representing Indigenous people on the extinguishment debate. And the extinguishment debate actually started with Calder in the 1960s, late 1960s. The Supreme Court of Canada dealt with it in 1973. And in that, the question that the Nishka from the Nass Valley raised was, well, has Aboriginal title been extinguished in British Columbia? And the court said, the court divided on that question. 3 of the judges said that extinguishment was accomplished. This is the government's raising their defenses of how is it that they got title to the land. And so 3 of them said, oh yes, well, extinguishment was accomplished by Crown governments coming in and passing law in the colonial period, which basically took over the machinery of granting lands to others. And 3 of the judges said no, Aboriginal title has not been extinguished in British Columbia. You need something more than the government just coming in and setting up shop and handing out land to people. You actually need a clear and plain legislative intent of the government to extinguish. And one judge turned the case around on a technicality. So the matter was left over, and then in Delgamuukw, the chief said, okay, let's do it a little differently. Instead of going in as Indian Act band chiefs, and instead of, dealing with this without much evidence, in Calder there wasn't much evidence, let's just, all of our chiefs, our elders, all of the matriarchs will come in and we're going to show the judge what our system of law looked like and who we are. And then we're going to ask them, how did they get title? And so we had 380 days of trial, and there was the most amazing evidence given by the elders and the hereditary chiefs. And at the end of the day, at the end of the Supreme Court of Canada Day, the court held that Aboriginal title has not been extinguished in British Columbia. That is, the Crown has had every opportunity over that 30 years to justify its dispossession, and it never succeeded. The court said Aboriginal title has not been extinguished in British Columbia. It has a jurisdictional and an economic component. This is a title that is a subtraction from, it constrains Crown title, because Crown title can't overwhelm that. The federal government has a safeguarding role. The province's jurisdiction is constrained because it isn't complete without the time when Aboriginal title has been dealt with. That's a principle that was decided way back in the St. Catharines Milling case in 1888, where the court said that lands, mines, minerals, and royalties of the province are available to the province as a source of revenue when Aboriginal title has been dealt with, which never happened in British Columbia. The court applied that decision in Delgamuukw and said that Aboriginal title has not been extinguished in British Columbia. Now, the important thing about Delgamuukw is that this was actually a seismic shift in the legal landscape. But the government's political culture didn't shift, which tells you something about the relationship of law and the rule of law to how deeply entrenched the problems are when Crown dominance holds the status quo in place, which holds wealth and power in place, and it's very hard to get it to shift even when the law asks or requires them to do that. We saw that with the Royal Proclamation, and now we're seeing it again with Delgamuukw. So the government took about a year to think about what they're going to do with Delgamuukw. And meanwhile, there was a case called the Campbell case, where the court, the Nishka Treaty was before the court, and then Premier Campbell challenged, how is it that the Nishka could have jurisdiction which isn't controllable by Crown governments? And the court said, well, jurisdiction isn't exhaustively divided between the Crown governments. There's jurisdictional space because Indigenous laws pre-existed the assertion of Crown sovereignty. They continued afterwards. They've not been extinguished. They find expression in Section 35. So there's legal orders which are at play, which Crown governments don't have exhaustively the jurisdiction